Freedom is calling on the other side of the wind. So we keep on walking, though it tears through our skin. Feeling like a warrior that's not afraid to bleed. The fight inside's in all of us, so we won't concede. You can't hold us down, no. You can't hold us down, down, down. You can't hold us down, no. You can't hold us down, 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 yeah. Down, 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 can't hold us down. Every day's a battlefield between the light and the dark. Angels and demons try to tear us apart. Heavy on our shoulders is the weight of the world, but it makes us stronger, though the pain it burns. You can't hold us down, we never give up. Walking through the fire and the flame can't hold us down. 'Cause when the going gets tough, we're tearing through the metal chains. Can't hold us down, 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 yeah. Down, 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 can't hold us down, 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 yeah. Down, 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 can't hold us down. You 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 can't hold us down. We never give up. Walking through the fire and the flame can't hold us down. 'Cause when the going gets tough, we're tearing through the metal chains. Can't hold us down, 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 yeah. Down, 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 can't hold us down, 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 yeah. Down, 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 can't hold us down. Can't hold us down.
Well, hello, and welcome once again to Talking Normal. And tonight I have my co-host with me here, Rosemary Dalton. Rosemary, how are you doing this evening?
I am doing great. How about you?
Amazing. Lots gotten off the chest yesterday, and lots needed to be said. And unfortunately, we'll kind of dive into that just a little bit, but just slightly, and we'll have you kind of talk about this. I think, coming from someone else who, is not in the mix, I think it really gives a little bit more credence and credibility to kind of really the reason behind everything. So I'll let you take the floor here for our introduction, and then we'll get into our next guest.
That works. Well, let's start off with the credibility. Everybody's sitting there pointing fingers and talk about credibility. Well, you need to look in the mirror. That's for starters, because there's a big fine line before in front of everybody. One, what kind of advocate are they? This should be the question. Are they advocate that goes into court? Are they an advocate for media? Are they a radio host advocate that gets your word out and exposure? Are they a support advocate? Are they, what kind of advocate are they? And that's what the question is. So everybody has their roles. Everybody plays their part. And that's where credibility comes in. Now, everybody says, oh, credibility. Credibility was questioned. Well, I don't care if you think I'm credible or not. I've brought kids home. I'm a minister. I'm an accredited press. I have accredited press pass. So I have credentials and accreditation. I don't need the approval of Facebook. I can go meet the president if I want to, walk in there and do an interview with him because I'm accredited. So if I give them accredited, I can walk into a courtroom and give them my documentation and affidavits, a sworn statement, and it will stand water because I have accreditation. That's accredited.
Right.
And when you are accredited, that makes you valuable in this movement, period. So these are the people you want on your side. Okay, that's for starters. 2, when you sit there and you point the finger, oh, birds of a feather flock together. No, right is right and wrong is wrong, period. Now, when you have radio hosts, their job, what is their job? Their job is to expose the truth. What evidence that is put before them, period. Now, if people have different evidence and they're sitting on it and they don't want it to be exposed, that's on you. But if you can counteract what that person has in front of them, then why isn't it being brought forth? That's another starter. You know, if you got evidence that says that other person's lying, bring it forth. A radio host is the best way to get it out there because that's what they do. That's a platform. Now, if you got a platform, that's where exposure comes from. Now, a lot of radio hosts do music. A lot of them do entertainment. We do talk shows. That's what we do. And talk shows is to expose the truth, period. What truth is put before us. No different than what truth is put before a judge. We don't know anything else unless except what was put before us. So if you are not putting it out, then how are we supposed to know? All we got is the evidence that we see that's out there. So let's see, accredited advocates. Well, one thing I do know is an actual advocate is Randy Davis. He is an actual advocate. He goes into courtrooms. He wins children home. He is accredited. One, he's an Indian chief. He fights for Indian children. If you're one of his people, he goes into courtroom because he's a chief. They'll listen to him. It's called accreditation. He stands up for his people. Okay? He does what's right is right, what's wrong is wrong. Period. And if he's wrong, he'll take accountability for it. That's how Randy Davis is. But if he's right, he'll stand strong on what he's saying, period. And if the evidence points in that direction and he has all the evidence and he can back it up, he will not open his mouth unless he has actual evidence to point it out. This man is a very honest man. I know him. I've known him for a very long time. So, and I've watched him bring kids home. That's credibility. Mm-hmm. What is he doing right now? Well, people out there with the evidence that he has been put forth him, he's got to protect the people. That's what he's doing. So if you think he's doing drama, well, you're wrong. He's protecting the people because these people that are being robbed or manipulated or misguided or misled, he feels they're in danger. So he's trying to correct the problem because that's what he does. He's a warrior. That's a warrior advocate. Something completely different than what you're used to. That's what they do. They fight for what's right. They fight for the evidence that's put before them. Now, if you have different evidence and you say something different, and if you can prove him wrong, that man will say, I'm sorry, because he will take accountability for it. That same goes for Jay Moss. Jay Moss is not an advocate. He's a radio host. That's what he is. He goes and he reports what's real. He is like a news reporter. That's what he is. The facts are the facts. What is put before him? That's where his accreditation is. He's not an advocate that goes in the courtroom. He helps you get your story exposed, period. That's credible. You may not like him, but who likes CNN? Who likes Fox 2? Who likes ABC? How many reporters do we not like, but we do watch the news? It's the same difference. You don't have to like the host. You don't have to like the person reporting, but they do report on what's facts. And if you have different facts, then that evidence needs to come forward. That's how they do their investigation. Everything is investigated before it's ever reported. Everything is investigated and seen. And everything he speaks about is based off documents. There are documents to back it. So that's what they talk about. What's in front of them, what's on paper, what's been real, what is actual there. So that's how that goes. Then you got Sher Lagares. Somebody said, well, because she got on a live show and somebody else came up behind her. You can't pick and choose who guest hosts come on. Anybody can come on. Everybody has the right to speak their truth that they think is true. That's called advocacy. Advocacy is using your voice, whether it be true or not true. Everybody has their own truth. So if you're telling them not to be friends with them, then you're silencing them. They have a freedom of speech too. They have the First Amendment right just as well as you do. So why can't they exercise their rights, but you can? What makes you any more powerful than they are? So their opinion, or because opinions are like assholes. I'm sorry about my French, but opinions are like assholes. Everyone has one. So everybody has a right to their opinion. Everybody has a right to their own voice, and everybody has a right to their own truth, because there's their truth, your truth, and then the actual truth, perception. What's actually there in black and white. So what they believe is one way and what you believe is another. That's when you need a mediator to view everything and find out, is it a misunderstanding or is there really a serious problem here? And 90% of the time, it's a big, giant misunderstanding that people got escalated because they're heartbroken and they're in their feelings. And in this movement, there's a lot of PTSD going, so there's a lot of triggers. So you got all these things going on. So not everyone's going to get along. Not everyone's going to see eye to eye. But does that mean you silence the advocates? Does that mean you silence the people that are speaking out? No, it doesn't. Let them speak, share their stories, because it doesn't matter who writes it. It doesn't matter who broadcasts it. It doesn't matter. If that person's on that air and they're speaking, they're trying to tell you their story. And every person in this movement is a victim of this movement. They're part of the system. They have been victimized by the system, and we're all survivors. And the only way we can stop this is giving awareness by telling our stories. So if you silence the radio host and you silence the platforms that are out there that are giving this, because they're shutting down all the media platforms on Facebook. So all we got left is the radio. So if you guys start isolating that, how are you guys going to get your stories out? Because everybody's picky and choosy. Everybody's biased. They want to pick their friends and only put their friends on there. They don't care. I don't do that. I pick and choose by legitimate cases. I pick and choose by, if you're a drug addict and you are a child abuser, I'm not going to put you on the air. I'm not going to make you look bad. I want you to clean up your act. I want you to get progress. I want you to get help that you need so you can get your kids home. And when you win, then I will put you on the air. When you win. But not until then. Because if you talk about your case before you win and it's active, then they can gag you. You shouldn't be talking about your case. Your advocate should be talking about your case. A news reporter should talk about your case. Somebody from the media, a radio host person should talk about your case. A journalist should talk about your case, but you should not. You give them the information, let them be your mouthpiece. You keep your mouth shut. Because if the courts, because they do watch these videos, if they see this, they bring it in there, submit it as evidence, and they gag you. Too many people have been gagged because they open their mouth and won't tell their story. They want that because we know it's wrong, but that's why there's advocates. So we can tell your story. So we can voice your voice while you're in the middle of the trials. Because if you're talking about it, they'll use it against you. You put it on your page, they're going to use it against you. You put it out there, they're going to use it against you. If you're not talking about it, then you got probable deniability. They can't hold you liable for what we say. They can't hold you liable for what other people say about the case. And nobody can prove where the information came from. So we get the information, it's leaked to us, we expose it. That's what media does. And that's what we're supposed to do. So you can either accept the fact that we are trying to go into a new direction here. We are trying to show people the right way of doing things. Now, what Jay does on his personal page is what he does. And I understand that there is a big old thing going on between different advocacy groups. Whether I believe it's right or whether I believe it's wrong, I don't condone any of it. And Jay knows that. I don't. But what am I going to do? Am I going to be biased and pick sides? No. Why? Because I believe very strongly every one of you are a victim. I believe every one of you are suffering from PTSD. And one way or the other, we're going to get through this. Because we cannot win this fight against CPS or the family courts or anything like that without each other. So until we get off our high horses and start working together as teams, like we're supposed to be doing, it's not going to get anywhere. But each one of us have our different roles. Each one of us do the things that we're supposed to do. We can win this. Everybody has their important roles to do. Me, I'm a support advocate. I give support. I give emotional support. I help with coping mechanisms. I help you get through the process. I help you get through what you're going through so you can stay strong, learn your voice, empower you, and teach you how to be your own advocate. That's what I do. I educate you. I teach you how to research, how to find the laws that you need, how to help yourself. And that's what I teach you, to be independent, because you need to be your own voice. You need to be your own advocate. And that's what I believe, because I believe you need support. And that's what you need. You need somebody there to stand by you and help you along the way, not bring you down, but bring you up. We give you hope and faith in yourself. And that's important. And nobody thinks it does. I'm the only advocate that really does this. And this is what I believe you need. You need this to get through this system. Everybody has their own special techniques. Everybody has their own special ways of doing things. I'm a teacher. I teach you how to cope. I teach you how to research. I teach you how to be resourceful. I teach you how to get resources. I find you advocates that can help you in the courtroom. I help you and guide you. That's what I do. It's my favorite saying. I can lead you to water. I can't make you drink. It's up to you to do the rest of the work. I can teach you. That way you'll learn for a lifetime. I can show you so you'll always have that knowledge, or I can just do the work for you and you'll never learn. The choice is yours. So I'd rather teach you. I'd rather show you how to do it, how to be your own voice and empower you. And that's important, because the more people that are empowered, guess what? The more awareness that's out there. The more awareness is out there, the more we can get ground and people standing up. The more people that know our cases after they're finished. And that's what I said, after they're finished, the closed cases. Those are the ones that need to be speaking out. But the ones that have open cases, they need people like me or Jay or Randy or Cher or even Poor Hold of Justice, somebody's platform to tell your story. Somebody else has to tell it for you. You can't be the one telling it if you got an active case.
That's right.
You can go to Terry LaPointe. You can go to all kinds of different people. But it's pick and choose of what cases can get on there that meet the criteria. With me, everybody meets the criteria. Just you got to take turns. Everybody meets the criteria.
Right.
That's what it comes down to. So credibility. Everybody wants to attack at credibility. How do you attack it? What do you do for the movement? That should be the question. What are you putting forth? Are you out on the street corners marching? Are you sitting there protesting? Are you getting petitions signed? Are you going to legislators and talking about what's going on in the courtrooms? Are you trying to change legislation? What are you doing? Fighting and bickering back and forth on Facebook? Trying to rob Peter to pay Paul? What are you doing? What you are doing is what makes credibility. So if you're not bringing kids home and you're hurting people's cases, that's your credibility. If you are bringing kids home and you got people who look at you and say, okay, you're a good advocate. You really know your stuff. You're a great teacher. Then that's your credibility. And if you're a mediator, being on the media, radio and stuff like that, you don't need anything because it speaks for itself. Right. We are the platform. That's what we are. We're a platform. So those stories can get heard.
That's right. That's
what we're going to do tonight. We are going to bring on a very special case here in Missouri. And this case is big. And the reason why it's big is because right now it's in the Supreme Court. I don't know if it's state or federal, but it is in the Supreme Court. And we're waiting on a decision. So we're going to go from A through Z, and we're going to let them tell how they got there. Right. Where did it start, and how did they get there? And what did they use to get there? Because that's important. So if you want to bring Dennis on, that would be great. And if Cher comes on, bring her in too.
Yeah, I'm trying to do that right now. Let's see here. Looks like we're starting to get Dennis. Okay.
Hi.
Hi, Dennis. How are you doing?
All right. How are you,
Dennis?
Sir? Awesome.
Hi, Rosemary.
I want to start out here, and I want you to start. I want people to know how you got into the system. That's kind of keep it summarized so we can go to the next step of it, like we discussed before. But how did you get where you are? How did it start?
Well, it started just as any other normal custody case would. in the circuit court. And what had happened is I actually won. We settled outside of court, and I had my children Sunday through Friday, and my ex-wife would get them on the weekends. And so that's what she settled for and all that, because of a lot of the evidence that I had that, didn't paint her in the best light, to say the least. And so since I had all of that evidence and that, they went ahead and she agreed to settle out of court. And this is what she agreed to, was we just set up everything. And literally after that was done in August of 2012, August 1st is when we went to court. I believe the judgment was actually signed on August 17th of 2012. Then one day my ex-wife just decided that she was going to keep the kids and she wasn't going to give them back, and told me that the school already knew about it and the school was involved in it. And later we found emails in that of the school actually getting involved in my custody dispute with my ex-wife, stating that they were going to write a custody agreement, an arrangement for me and my ex-wife, that gave her more time with the kids. And so, and this is just a public school. It's, nothing special, nothing fancy, no military or private school or anything like that. It's just a plain old public school. And so they decided to intervene on my ex-wife's behalf and give her more time with the children, regardless of the court order that we had in place that stated that I have the children Sunday at 6 p.m. till Friday at 6 p.m. And she had them on the weekends. They said that she needed more time with the kids, so that's what they were going to do. And they gave me a calendar with my highlighted weeks on there. They changed it to week on, week off, and gave me a calendar with their highlighted weeks on there that they said that we needed to abide by. And they used their school resource officer to enforce their new custody plan for me and my ex-wife. And so, of course, I told them they don't have the legal authority to do that because they're not a judicial body. So they can't interpret a court order. They can't rework a court order. They can't do any of that because they're part of the executive branch. Mm-hmm. And throughout this story, that's where the problems are going to start showing up is the constant working between the executive and judicial branches of the government here in the state of Missouri. So the actual they made up this order, this calendar that they said that we were all going to abide by, and so then of course I filed a due process against them, and because the director of special education told me this is what they were going to do, and if I didn't like it, I could sue them. So I filed a due process against them and all of that. Well, at the same time, then they during the due process, they started shredding records. The school district did, shredding school records and just records right in front of me, which I have all of this stuff, everything basically that I speak about. I have mostly 3 forms of documentation. Either I have emails or I have written communication between me and the people, or I have video, or I have audio, and sometimes I have all 3 to prove, or like Rosemary was saying earlier about the credibility, to actually have the credibility. Right. So most of the stuff I have, like I said, 3 forms of identification or documentation on it of what they did. But anyway, so what they did in the due process was they then the school then called into Division of Social Services, and they got them involved and told them a bunch of outlandish things to get them involved and all of that. Which we did. I was able to, once I finally got to court, which took forever because the illegal activities that they were participating in the court system.
Can I ask a question?
Yeah.
Can I ask you a question real quick? So
Yeah.
you're telling me this is a custody case and the school intervened and then they called social services and brought social services into a custody case?
Yes, they did. I actually have the documents of where the school made up lies and where they said things were going on that were not. And they also brought in that we sued the school district in Camdenton, Missouri, whenever I was a kid. And they brought that up in there and said that, I sued the school district and that I was going to sue them and all of that. So that's what I came up with them is these documents and stuff, that this is their own what they reported to Division of Social Services. Also, right before all of that happened as well, I missed a step. My daughter's doctor hotlined my ex-wife. There's a lot of abuse and stuff in my case as well, on my ex-wife's behalf and her husband now. But my daughter's doctor actually hotlined my ex-wife for not taking proper care of our daughter and medical treatment and stuff like that. So that also brought a big problem with the school in that, because like even one part. Go ahead.
The question I have is, they allowed your kid, the doctor hotline, and there's abuse and everything like that on your wife, your ex-wife.
Yes.
They allowed the kids to stay with her?
Yes. They never investigated it.
How is that even, this doesn't even make sense.
Well, actually, there's another story that goes along with that. The agent or the DFS agent or caseworker that was supposedly investigating the hotline, her name appears on the investigation in August of 2012, but she did not start working for the division until October of 2012. So she didn't even work there, but her name appears on an investigation. And so this is how they have been able to cover up child abuse. And they did it by not even having people that work there on an investigation and close it.
So fraudulent documentation then, because
we're
going back in time and creating a document that didn't exist back then.
Right. Yes, it's exactly what happened. And there's actually more of it. And there's actually where they've actually shut down complete investigations. Like my children's therapist hotlined in and said that the children had told her that my ex-wife's husband was going to kill our entire family and kill the children.
And they let them keep, where's the kids at now?
They are actually with her in Arizona. With her and him in Arizona.
And the social services allowed this?
Yes, they actually, they kept saying that she was a good parent, that they sent her through their classes, and they actually lied on the stand and said that they investigated every hotline and they found nothing wrong with the mother or the husband. But as we got documents here in 2018, now that the trial took place in 2015. And I had been requesting these records since 2013, 2013, I believe, was the first one, was the first request. It may have been 2012, but I believe it was 2013. So from 2013 till I think it was back in March of this year, we were starting to get some documents, which we've gotten more since then. But
so what we're figuring here is approximately 5 years from when you requested the records until you received them finally.
yes, and I still haven't received them all yet, but we've gotten
So-
more than we ever have before.
I have a question.
Mhm.
In all this, now your mom's very much involved in this case, right?
Yes, she is.
Was her role in all this? And you could bring her on and have her.
Yeah,
kinda
I've got her
explain-
on here. I'm going to request it. I'm going to try
You know,
and turn the
That
camera.
way you can kind of tell us how she fits into all this.
Well, she has actually been a very big advocate of mine since I've been a kid. Like I said, she actually filed the lawsuit against the Camdenton School District whenever they refused to educate the children of the school district. So she's always been my advocate. She actually helped me out quite a bit with the due process that I filed against Lebanon School. Also, she has been receiving all of my documents for me and basically categorizing them, just making sure I get them. And she was one that had helped me prepare a little bit for trial. Most of my court appearances and that she's helped me out with. She's been to all of them, I think. There might have been one or two she hadn't been to, but she's been to basically all of them. So she's a big advocate.
So your mom is your greatest advocate and your greatest support, right?
Yeah, pretty much.
Hold on just 1 second. Remember at the beginning of the segment where I said you learn your own voice? A parent will be the best advocate for their children. Now, Cher is Dennis's mom, and she's been his advocate his entire life. And I've met Cher. I know Cher. She's not only his advocate, but she advocated for me and kept my son home. And she won my case. And Cher is one of the best advocates I have ever met. And she's loyal and devoted. And when she tells you to do something, you need to do it, period. Because if you're not willing to go through the edge, you're not willing to go through the hoops that she's telling you to go through to get your case won, don't come asking, because you will be vetted. You'll be sent away. She's not working on your case because she can't waste her time. There's too many people that need her help, and she's too great of an advocate to be wasting her time. And I'm going to tell you that right now. So I have a lot of respect for Cher. She's like another mom to me. I love you, Cher. But I mean,
Cher, what do you feel as as an advocate, number one, and what do you feel as a grandparent, almost going through this somewhat helpless because you're trying to help your son navigate the family courts, and he's getting attacked by social services, by the school for not doing records. How does this make you feel on that aspect, number one, as a parent, and number two, or as a grandparent, and number two, as an advocate?
Hi, Jay. Hi, Rosemary. Hi. Thank you for the kind words. It's very frustrating that because many years ago I advocated and I won the case in the Missouri Appellate Court, and then they tried to appeal it to the Missouri Supreme Court, and it was denied. It's very disheartening. It's very heartbreaking to know that because of what I did and what I have done for the last 20 plus years, and once I won Dennis's case, and even before I won the case against the Camden School, which is one of the largest, well, not largest, they call themselves self-sufficient school districts, one of the prominent districts in the state. Once I won that, and even before that, I mean, I began helping a lot of parents all over the state of Missouri, all over the United States. And it was so heartbreaking to see as a grandparent that my son was targeted and retaliated against in these written documents because I had sued the school district, and it wasn't a money damage, it wasn't a money damage suit. One, and because I had been to Jefferson City and advocated and talked with all the legislators and had my representative circulate a petition, against some liars in the House. And because I had done all that, my grandchildren were stripped away, placed in harmful situations because of what I had done.
Right.
And so that really pissed me off. And especially when I continue to read these documents, and it all relates back to Dennis's case years ago. And every single one, and the more that we became involved, and the more that as Dennis said, and I wanted to make one correction because Dennis does have dyslexia. So dates and things like that sometimes get confused. But this caseworker that had written this report and said she investigated that hotline call from my granddaughter's primary care physician was in 2013. And this was still during the time Dennis had the due process going on. And this hotline call came in August of 2013. And she didn't become employed because we did what's called a sunshine request. Dennis and I, we started looking at on the public website the salaries for Missouri state employees. And we started looking at her salary, and Dennis, had talked with her and all of that. Something didn't seem right on her salary. So Dennis calculated it up, and he said, Mom, I'm telling you what, there's something wrong here. Something wrong with her salary. So we did what was called a sunshine request, which is like a federal freedom of information request for her employment records. Well, lo and behold, there it is, straight out of their own documentation. She's the one on audio recording, which Dennis has that, on their own documentation, that she did this investigation from Nicole's doctor, which the school district actually, according to their documentation, they did the investigation. The school district now, which holds a contract with the Department of Social Services as one of their sister organizations. The state of Missouri, they cannot investigate, but they did. But she didn't become employed until October 1st. This hotline call came in August 27th and 28th of 2013. And that one, 2000, I don't know. I'm getting dates mixed up, but anyway, it didn't come in until after she, employed there.
Right.
So when we started looking at this, and then this school employee, she was also involved in a case that went up to the 8th Circuit Appellate Court that lost miserably against my sister, this special service director. Well, what Dennis didn't know at the time, and neither did I, she was a special friend and longtime friend of Dennis's ex-wife that was covering up this child abuse and this child molestation. That didn't come out until in court in 2015, when Dennis presented the Facebook. And here we go, Facebook. Facebook is a really, powerful tool. And at first, The ex denied that she knew her, didn't know, no, I don't know her except for school. But then when Dennis presented the Facebook and all of that, she recanted on the stand. And the judge in the case was just like, well, everybody lies. Everybody lies
What?
in these cases.
I told you,
Oh,
Jay.
so you're allowing someone to perjure themselves on the court, and you're letting them get away with it, right? A bold-faced lie right out there in the open. That
Jay,
right
it
there
gets
says,
better.
okay, again, Rosemary, where's your credibility? Where's your credibility?
Exactly. Like I said, I told you this case is a doozy. It's a very special case in Missouri. There's more. There's a whole lot more.
So in 2017, finally, they have an Office of Child Advocate here, which is supposed to be the oversight office of the Division of Social Services. So after many years of my complaints, they finally did a half-assed, partial investigation of DSS's record, Division of Family Services, Division of Social Services. They keep changing their name. Every time they get in trouble, they change their name. But so they did an investigation, and what they found was exactly what I had said. These cases were not investigated. They had no records of them ever being investigated. That the investigation was the exact same thing as the allegation. That was the outcome. And so these children had been crying out for help and help and help and help. And yet the Division of Social Services agents continued to cover this up on multiple occasions, working together, the executive branch and the judicial branch, secretly funneling by email, in which we have those now, just produced in 2018, secretly funneling their evidence and their opinion, which was half-ass evidence. Of course, now we know that. But what they claimed, their opinions and secret emails to a family court judges, 2 of them. And they actually even held ex parte hearings.
So you got ex parte communication, and you've got ex parte hearings going on too.
Absolutely.
If I could,
so far.
Yeah, Dennis, I'm going to go ahead and get back to Dennis here. I know that he had something to interject there.
well, I just wanted to put in there. I know Mom said that the kids were crying out for help. They were actually, during my supervised visitation that I got by their ex parte communication, they did all of that behind the scenes. But during my supervised visits, the kids would tell me that they were getting hit, that they were sick. They would tell me these things right in front of Division of Social Services workers, and they did nothing. As a matter of fact, what they did is in their notes, they wrote down the opposite of what happened. Almost 99% of these supervised visits, they have what I recorded all of them, audio recorded all of them. And what they wrote in their notes don't match the audios of what actually happened in the rooms. So that's just what I wanted to throw out there, and you know, kind of reiterate what Mom was saying of where the kids were crying out for help.
Right. So now we've got a Sean McMillan case, the right to lie, going on with social services and inside of this case. So now how, you know, because we're going to try and help some of these other people that are out there. How did you get through the process of, okay, we went through the civil court for the family court, we went through the appellate court, and now where did you go after that? District court and onto the Supreme?
Well, what I was doing whenever I got into the court, family court or circuit court, I actually found out that my lawyer was being referred clients from the judge. So,
What?
yes, he was being referred clients, and this is a text message from my lawyer to me, because the judge basically called my lawyer a drunk in open court. And I text my lawyer and I was like, you won't believe what the judge said about you. I was like, this is unreal. And he's like, oh, it's probably something about KU or me drinking or womanizing. He had, and I'm paraphrasing. This isn't the exact text message, but he says in there that the judge has complete confidence in his ability. He refers him clients. And I was like, and my exact words were, "You SOB. No wonder why you haven't filed anything to protect my kids." And he, yeah, it was a bad deal. He even actually wrote an email. He didn't file anything formal. He wrote an email to the judge during all this email exchange, and said that we should not have to let's see, what was he saying? There were so many emails, sometimes I get confused on them.
It was about his clients never had a hearing, but yet your rights were restricted.
Right, yeah, that's what it was.
So,
Is that
whoa, hold up. Your rights were restricted. Explain that one.
Well, during this process, it started in August of 2013. They actually separated the kids because my ex-wife lied and said that my son did something to my daughter, which was totally untrue. And I actually had the video from the week prior that they told my son and daughter that they were going to send them to jail and for breaking a Missouri law. And so I've got all that evidence and I brought in the pile of paper of medical records that to Division of Social Services to exonerate my son because all of the abuse, which as it looks now is sexual in nature as well as physical. It's hard for me to talk about.
Oh, that's fine. And explain
If
how
you need
old
your
were
mom to explain it, to give you a breather, let her do it.
Yeah. And
It
how
all
old were the children?
happened when Kyle, my grandson, and I'm going to use his name because here's why. The court system in the state of Missouri, in order to shame and punish the Lagares family, decided it was a good idea on what they call CaseNet, which is the public case viewing. They decided it was a good idea when this court order came down by secret ex parte emails. Keep this in mind. No hearing, no anything. When that court order to separate the two children came down, they thought it'd be a good idea to publish my 7-year-old grandson's name, address, date of birth on the public court website.
Did you just say 7?
He was 7. My granddaughter was 6.
And what was he accused of?
He was accused of touching her.
Wait a minute.
But
So-
here's the kicker.
No,
The
I have a
mother,
question.
hotlined him.
Wait a minute. A 7-year-old and a 6-year-old, brother and sister. I'm sorry, that's called healthy sexual behavior by any psychological child development. Of course, I'll tell you, children get curious and they want to know why boys are different than girls. And
But
they say,
here's
well, I got this and you
but
got
here's
that.
the
Why
thing.
does that work?
These medical records that Dennis talks about, it was 18 months of medical records with vaginal rawness, vaginal bleeding, all these horrible things. And Kyle was in Dennis's custody and Nicole was only in the mother and the boyfriend's custody. They were not together.
But a 7-year-old can't even do any of that stuff. A 7-year-old stuff doesn't work like that. It shows that in child development.
This is what they did.
Oh, it couldn't make it bleed. It couldn't do any of it. It's too small.
But here's the kicker. When Dennis received the video of that forensic interview, guess what? Social services had written reports that, oh, Nicole had said that Kyle had did it. But here's the kicker. She said, I don't know if Kyle ever did it, but I know my new daddy did it.
Wow.
And they covered that up.
So you're saying your granddaughter said that?
Yes, it's on the video.
Yes, actually.
And they didn't take, oh my God.
They actually, you were talking about the gag orders earlier, Rosemary. They actually came in and tried to put in a gag order on and tried to take away the DVD to hide that evidence. They tried, but we had already got it all taken care of in that. But that is part of the issues, and that's the court stuff. As far as in like the state court and that the circuit court, the lawyers in there that are these so-called guardian ad litems. In my case, I had let's see, 1, 2, 3, 4. I think I had 4 or 5 in my case. One I had kicked out of my case because well, after I fired my lawyer, I started representing myself. The one that was getting referred clients from the judge. I started representing myself, and we started researching. Well, I'm going to be honest. Mom did 95 or almost 100% of the research. But as far as laws and stuff like that, and we found, or she found, the statutes for and the Supreme Court rules of the guardian ad litems. Well, they are supposed to be trained. They are supposed to have a certain amount of hours. They are supposed to do certain things. Go ahead.
It just does have a certain license or something like that?
It's not really a license, but it is a course that they have to take. It's continuing education is what they call it.
And also
there's supposed to have by statute, they are supposed to take a permanency planning course, training program. And most of the lawyers we have found out, at least in the 26th Judicial Circuit, do not have those. They do not have the qualifications to be guardian ad litems, but yet they are acting as guardian ad litems. Also, there is a federal law called CAPTA, C-A-P-T-A, CAPTA, which is the Child Abuse Prevention and Treatment Act. They also have, when there's abuse cases arising, they also have rules for the guardian ad litems as well. One of their main rules that most of your guardian ad litems do not have, which I actually have my guardian ad litem, my latest one, stating to me on a phone call that I recorded that he did not have the early childhood education and adolescent childhood education. They're supposed to have that in order to be a guardian ad litem, so they know what a child's best interest should be, which was supposed to educate them is what that would also help. And this guardian ad litem, Gerald J. Harms, he actually stated to me that no lawyer is going to have that, that he didn't have that training because if he took the time to have all of that training and stuff, he'd never be a lawyer. He'd still be in school.
Here's what I found out. In 2015, when I began investigating this, I found out that the Missouri Bar did not offer the training and the courses for any guardian ad litem in the state of Missouri per capita. Now, each state has what they call a capita plan. And with that capita plan comes funding from the federal government. Well, in Missouri, according to the Missouri Bar, none of their attorneys were trained. None.
Oh, wow.
So at the time, you've got no attorneys in the state that are being trained in the Child Abuse Prevention and Treatment Act.
That was correct. Yes. And so what they did was they decided to offer what they called a continuing ed class for 3 hours after I called up the Missouri Bar, and they decided to offer a 3-hour course for continuing ed, which is definitely not what CAPTA requires. It's definitely not what the state statute in the state of Missouri requires, right? Because they require a permanency planning course, which is about a 60-hour course. It's not a 3-hour continuing ed. So what we have is, and the state of Missouri, through the executive branch, takes in all this federal money, but yet they didn't pay it out to train these attorneys. So we have attorneys then are going, oh, well, yeah, that's just in the best interest, you know, oh, yeah, it's the best interest standard, when they don't have a goddamn clue what the hell they're even talking about. So we have guardian ad litem fraud in the state of Missouri. We have these attorneys that tap in to these trust funds, get paid thousands and thousands of dollars for that. Now, so one judge told Dennis that he didn't care if he was qualified. It was a guardian ad litem that was appointed in an order of protection, which Dennis had filed, which he never got a hearing on in years, never got a hearing on his orders of protection for the children. But he told Dennis he didn't care if she was qualified or not. He was going to point somebody out, which means the local bar. And so we have all of this going on in the state of Missouri. And so when Dennis actually exposed that and filed this into the court, he did have that one guardian ad litem removed in his case, which basically is case law for the state of Missouri, having this guardian ad litem. The judge got so frustrated with Dennis for exposing that, he said, well, I don't agree with it, but the law is the law and I have to remove you. Now, this was on trial date. This was on trial day. Wow. So
now I have a question. Throughout this entire process, well, you guys going from court to court to court, and this goes to both of you, did you ever use the UCC laws, the contract laws, commercial laws for any reason to help you proceed? Or did you just use the guidelines, handbooks, the statutes of Missouri, the state laws and stuff like that? What did you use?
Yeah, just the UCC JEA, which is Dennis is just using that now since his children have been taken out to Arizona, which the local court is actually ignoring. And Dennis, you want to talk about them hiding your audio recordings of the trial for over 2 years, so you could not get an appeal?
Yeah, that was what I was going to go to next after we talked about the guardian ad litem fraud, well as
yeah. Let me get this right. So the case went from Missouri, and then went to Arizona because she moved with the kids, correct?
No, the case is still in Missouri, because I filed the paperwork and I filed all the court cases here. Okay. She had not gotten residency out there in Arizona. I am still fighting the decision as well as the judgment to allow her to move out there and allow her to have the children. So I'm
Okay.
still doing everything in Missouri.
Okay.
But
I have one question before
what
you
they
go
did.
on, before we get to the gritty.
Go ahead.
For you and your mom, I have one question. Through this entire process for the last 5 years, has any other advocate stepped up other than myself to help you?
No, I don't think of too many. Mom, can
No.
you think of anybody?
Nope.
I'm
Not one.
just curious because I have been there for support. I'm a support advocate. Have I not been, Cher?
Yes.
So I have been there, but where are all these advocates that want credibility? That's where I started off with this. This case
Well-
is a bad case. These kids are being abused by the mother. There is proof and documentation on this. And these two are fighting this case by themselves. And the only advocate that's ever came to help them is me. Where are these credible advocates? And that's the biggest question. Everybody wants to talk about credibility. Everybody wants to point fingers and you want to talk about how winning cases. Why don't you get off your butts and try to help in this case? Because it's in Supreme Court. These kids are in danger and they need extra hands on deck. So where the hell are all these people? I would like to know. That's a good question for the
Yeah.
public, wouldn't you say?
Yeah, I think it is. I think it's a very good question. Yeah.
Yep.
Yeah, I'll definitely let you go ahead and go on there, Dennis.
I'm sorry, I had to
Well,
interrupt for
that's
just a second.
Oh, that's all right. Yeah, I mean, believe me, I really appreciate everything you've done, Rosemary. I really do. I mean, we went to the Capitol together.
Yes, we did.
We've done a lot of stuff, you know. So, but with this case, I had missed an actual day of trial because my mom had gotten sick. See, I asked for my ADA, Americans with Disabilities Act accommodations in the circuit courtroom, in which I was not asking the circuit court to do anything. I was just asking them to allow me to use my accommodations, my computer, my recording device so I could record because I don't take notes, you know, because of my dyslexia and that. I take horrible notes. My handwriting is atrocious. I have dysgraphia. So I was just trying to, I wasn't trying to inconvenience the court or anything. I was just trying to use the accommodations that I was providing. One of them was an ADA advocate, which they denied all of my accommodations prior to me going to court. And the judge said, and I actually have his order where he denied all of my accommodations. And he told me,
Electronic evidence. You could not bring in your recordings, your
Right.
electronic evidence.
right, yeah, he wasn't going to let me bring in my recordings, evidence, electronic evidence, anything like that. They weren't going to let me bring in. He told me that I didn't need that stuff. And keep in mind, there was no hearing or anything to determine whether or not I needed these accommodations, which they are required by the Americans with Disabilities Act if there's a suspicion that you have a disability. They either have to grant you the accommodations you're requesting or have a hearing and for you to show the court or tell the court, this is why I need these accommodations. And neither of that was done. So that right there, they violated the Americans with Disabilities Act, which they do a lot with people with disabilities.
Yes, they do.
I mean, they do. They take sole advantage of people with disabilities. But so what I was doing in there is I went to trial, asked for my accommodations. They denied them, all of that. It wasn't till the second day of trial that the judge finally, because I told him I wasn't going any further in this case. I said, we're not going any further. I need my accommodations. He throughout this whole trial, he's made fun of me. He's poked fun at my disabilities, all of that. And so the second day of trial, I told him, I said, we're not going any further. I said, and I cited the case laws, Tennessee v. Lane, all of that say that if a court, and I told the judge this, if the court does not honor the ADA accommodations in that, they lose all judicial immunity. And I quoted the Tennessee versus Lane case in that. So he finally allowed me some of my accommodations. He allowed me my computer, and he allowed me some of my electronic evidence in that, which again, I was in the middle of trial. I was not prepared for any of this.
Right.
I asked him for a continuance, and he denied me a continuance or anything to get my ADA advocate. So my mom was the only one that was there that knew my case. I had no way to have anybody else do it. So my mom became my ADA advocate, as good as she could do. And, you know, I love my mom dearly, and she tried her best, but she is not a secretary in any way, shape, or form.
Right.
What she did do was, I mean, she knew the evidence. She knew the case, all of that. Like I said, we weren't prepared to have all the electronics. We had to do it by paper. What the judge said is I had to do it by paper, because they've done it that way for 100 years, and that's the way we were going to do it.
But the attorneys were allowed their computers, their cell phones, all of their evidence by computer, but you were not.
Right. Yes. And that is the truth. The attorneys were allowed everything. They even brought in a projector screen for one of the attorneys, and they wouldn't let me use that, to use my evidence on it. But anyway, like I was saying, we went to trial. Second day, I got my ADA advocate, which was my mom. Well, who was there. She's not really an ADA advocate as far as a trial setting is concerned. But she was there. She helped me out. Well, she got sick, and I had to take her to the emergency room because I was the only one there with her. So I had to take her to the emergency room. Well, they proceeded with the trial without me. And I notified them. I asked for an emergency continuance, all of that. They asked me where she was in the hospital at. They wanted to know what she was sick from, where she was at the hospital, all of that stuff. And I just told them, I said, well, my mother's medical stuff is confidential, but, you know, I'll tell you, she's at whatever hospital it was. I don't remember the name. But I told them the hospital that it was and everything. And I asked them if it was going to be postponed. And I was talking with the guardian ad litem because he was the one that contacted me on behalf of the court. And so I never got a response after I gave them the information. Well, come to find out, they went ahead and had trial without me. And they had the sheriff's deputy that was in there, or the bailiff, or whatever they want to call him. It's a sheriff's deputy for this court. And they had him testify that he called to the hospitals down in Springfield, Missouri, and they didn't know, they had no recollection or no record of my mom ever being at a hospital. And so they basically made up a whole story to where, because they didn't check all the hospitals in Springfield, there's actually 3 of them. They only checked 2. They knew there was 3, but they only checked 2. And I already gave them the information of which one it was. But anyway, so they went ahead and had trial without me. Well, during this day of trial, they put on the Division of Social Services Workers. And so they, of course, then they committed perjury, 100%. Most of the things that they said on there, they wanted to say that I had Munchausen syndrome, but there's never been a diagnosis or even a credible accusation of that against me for the children or anything. And so they even elicited testimony that I followed the Division of Social Services Workers, but yet I have the videotapes that I took of them following me. And and I presented all this information to the guardian ad litem and told him that they followed me and all of that. Well, he asked them, well, did you ever follow him? And they said no. And he said, oh, okay. But he's seen the video. So, of course, they elicited all this fraudulent testimony, all of that. And I didn't know about this until the next day when I went to trial, or whenever it was, whenever we went back to trial. And then I got copies of the trial. Okay, they have audio recordings in the courtrooms that are considered the record for that, instead of having transcripts. Right. Instead of having like a court reporter transcribe everything, they have the court reporter doing the recordings. And so I got a certified copy from the circuit clerk's office of these CDs. I've got both days. There was actually 3 or 4 days of trial, 3 days, I think. But there was 2 days of the trial audios that went missing. And now, keep in mind, I already got a certified copy of these 2 trial dates. Well, the circuit clerk's office said, which Joe McAwee is the circuit clerk of Camden County, and her office stated that Dee Lane is the actual clerk that was involved in this.
Susan Medley on that trial.
Oh, okay, yeah, Susan Medley. You're right. I apologize about that. Susan Medley actually sent me my emails, and I have the emails back and forth of where they are saying that these trial audios do not exist, that they were never made. And so everyone knows if there's no record of it, it doesn't exist.
Right.
So these 2 days of trial didn't exist now. Okay. So they hid them. Well, for 2 years they hid them. And I kept telling them, I know they're there. I need you to, because I was trying to file an appeal. Mm-hmm. And in order to file an appeal at the Missouri Appellate Court, depending on which division you're in, but the Southern Division is the one that I was in, I was trying to file the appeal, and you need the record on appeal, which is the entire case file of the court proceeding, as well as these audio recordings, which these audio recordings have to be sent to the Missouri. Mom, do you remember the name of that place?
State Court Administrator.
State Court Administrator. There it is. So they have to be sent to them by the circuit clerk's office. So my certified copy, I could not send to them. They have to be sent from the circuit clerk's office to the State Court Administrator to be transcribed. Mm-hmm. Then that has to go to the Missouri Appellate Court, Southern Division there, and before you can even attempt to do an appeal. Well, with these being hidden, and I even have the letters that the State Court Administrator wrote saying that the circuit court would not send them over, would not send anything over.
$50 for the appeal.
What was that?
You did pay the money for the appeal, and the appellate court was waiting on the transcripts.
Yes. I paid all the money. I filed the correct documents at the circuit clerk's office in Camden County to do the appeal, everything. And then I had to do 2 continuances with the appellate court and telling them that they refused to give the record on appeal.
Hold on 1 second. I want to interrupt you just a second. In the state of Missouri, in order to appeal a case, you must have all the file, every little document, every scrap paper. Everybody keeps asking me the question, why didn't I appeal my son's termination rights when I could have? But I tried and I couldn't. Why? Because they locked it up in Blueberry Hill vault and they won't let me have it. To this day, I still don't have my son's record. And without every piece of scrap and every transcript, they won't let me have it. I can never appeal my case. Right. Missouri is very stern about that. They will not let you have it, period.
Right.
Yeah, fight tooth and nail.
always like
Get
that
it.
too. Yeah.
Let me tell you why, Rosemary. Here's the thing. Anything that is involved, that social services is involved with the family court proceedings, there's a state statute, 47.140. That was enacted, I think it was 1974, 75. Okay. In that state statute, it specifically states, in order to maximize the federal monies, the family court, the judiciary, and the social services branch, the executive branch, can enter into a co-op
Contract.
agreement.
Mm-hmm. They're entering into a contract is what it is.
Exactly. So now in Missouri, we do not have separation of powers by this statute. There is no separation of powers when you have the judiciary working with the executive branch, which is in fact what happened in Rosemary's case, and which is in fact happened in Dennis's case, when they secretly work together as one unit in order to strip parents. And here's the real kicker. The Missouri Attorney General's office represents both of those entities. If you file a federal lawsuit, they enter, and you can name the people individually, social service workers, right? Individually, but the Missouri Attorney General's office enters to represent these individual liar, perjure, social workers, which they can't do. They can only enter into a case on behalf of the state. That's it. Right. They can't enter according to our statutes and according to the authority of an attorney general. However, they do. They really do. Right. And so we have a big problem because we don't have separation of powers in the state of Missouri. We do not.
So to interrupt you just for a second, Cher. My case happened in 1997 to 2001. Dennis's case started when?
Dennis's, which case?
The one that he's in right now. The one they break all the rules in. When did it start?
2010.
So this is many years, almost 2 decades after mine already happened. And I've already gone through everything Dennis has gone through, and I lost my son over it.
Right. And now you know about the guardian ad litem, you know, in Missouri, you know, I mean, there's a lot of things that are wrong. And in order for Missouri, like Governor Greiden, which is resigned, and now we have a new governor, right? His budget, 1/3 of the budget, social services for the state of Missouri. There's a problem when you have 1/3 of the state budget for social services, which comes from our state statute that says in order to maximize Missouri funding, they were going to co-op and join basically the executive and the judiciary, which the Department of Justice in 2015 in your county, Rosemary, came in and they investigated in St. Louis County Family Court.
The same court that I went through both times. My son and my daughter's
case. And they told them, you can't do this. You guys can't all work on one team.
FBI did that. And they cleaned up the courthouse and they put new people in place and new judges, and they changed it all around. They even got rules now they must abide by.
They're still doing it.
The same court that took my son, terminated my rights illegally. And the same court
separation of powers.
They didn't even separate the powers of a restraining court and a CPS case between the assailant and my daughter. I mean, how could you do that to a child? I mean, I have him in restraining order court. We're supposed to go to a higher court, and they bring him down to the juvenile court. He's not a juvenile. He's an adult. They put him in front of the same judge. that's not separation of power. They have
Right.
these rules there that, and they say, well, the same family. He's not family. It should have been in court.
Well,
It's
this
not-
this is how it's kind of explained. You've got executive and you've got the judicial branch, right? Whenever they come together, guess what happens? That's the family court, and it's called a quasi court. And that's what they're calling these things now, is a quasi court, where they're overlapping everything. And what ends up happening is the good laws get thrown out. The good statutes get thrown out. And what's left is the bad statutes that incriminate parents, that throw in their prima facie type evidence where you have to prove your innocence rather than them proving that you're guilty.
And what's worse, Jay, is when Dennis was able to recover the secret ex parte emails between the circuit clerk's office, the judge, and Division of Social Services, which was not a party to his case. His case was never a social services case. It was a little, just a regular custody modification case. That's all it was. But when these emails were discovered in May of 2018, this year, actually, and keep in mind, they definitely tried. They tried desperately fixing, they tried really, really hard. And in 2018, it was discovered that these emails that do not appear on the court record anywhere, they're not in the judiciary, that they held these secret hearings with Dennis's ex-attorney, Division of Social Services, which was not a party to the case, never a named party to the case, and the judge.
So basically, because of the fact that Missouri is operating on social services budget of 1/3 of the budget, they're basically dictating what the entire state gets to do and what they get to say, how they
now you're catching it, Jay, and they all sweep it under the rug, and it's never been exposed. This is where you come in. This is what I said. This case needs to be heard. Now, before they continue, I want you to tell me, what did you get out of everything they've said so far?
Well, what I've got a whole list here because I've written everything down on this. What I'm seeing is fraud upon the court. I'm seeing we've got ex parte communications, we've got ex parte hearings, we've got social services getting involved in a regular old divorce case, which has no bearing whatsoever. And now they're asserting issues that don't even need to be asserted. Really, this is still in the realm of actually being just a regular old divorce case hearing, except for the fact of if there's abuse on the child, that needs to be a separate issue that goes with social services and the mother, not with Dennis.
Here's a real kicker for you, Jay. Division of Social Services in 2014 filed into Dennis's custody case that they never made any recommendations, ever. But yet, now this comes from Brian P. Weasel, which got elevated from the Division of Social Services into our Missouri Attorney General's office. Okay, he filed that. They never made any recommendations. Yet, in 2018, the emails were discovered that, in fact, social services and the judge were communicating in secret emails.
So where was all of this kept? Was this kept back in Al Capone's vault? I don't know.
Yeah. Well, the only way that these were discovered is by Dennis's continued persistence, and they were discovered off of the Division of Social Services email servers.
Wow.
Email
Discovery.
servers. That's the only place they exist.
So Discovery
Never
really
filed
was your
in
key.
case. The judges there was 2 judges. The judges have never filed them into the case. The circuit clerk's office say they don't know anything about it, but yet we have the emails between the ex-wife's attorney to the circuit clerk that says, don't file this into the case. Don't file these.
Are you getting what I'm telling you now, Jay?
Why fill them out? You know, I don't get this, because, okay, you know, if this guy's doing what he should be doing as a father, fighting for his rights, fighting for his children, why are you denying him the right to file what everybody else has been filing, because there's a social services case based on something that wasn't even within his responsibility realm?
Now, remind you, Jay, this is a 50-50 state, okay? Hold on, Sher.
All of those cases were unsubstantiated by the records in which Dennis provided to the Division of Social Services. There was never anything substantiated against Dennis. But here's what we found. In 2014, they had a secret ex parte hearing, the mother, in which the email showed the mother was aware, and her evidence in the email showed that her evidence was being funneled to the judge secretly. That's what their own documentation shows. This ain't any made up bullshit.
So she knew that her information was being filtered to the judge, which makes her a party.
Yes, she sent it, and it says in her own emails, Amanda is aware, which is the ex. And this stuff was, now keep in mind, Dennis never had a hearing, ever had a hearing to put him in supervised visits, ever had a hearing until this started, the second, the modification started in January 2013. He never had one hearing, evidence hearing, until he went to trial in 2015.
So now there was a secret order put in place. He was given the order, but he didn't know about the trial or anything that was going on. Gave him an order. Hey, by the way, you're going to have court order visits now.
Right.
Really?
And not only that, but in 2014, after he had exposed the guardian ad litem fraud in the court and won that, after he had exposed the ex parte communications of what he knew at that time, this is what they did. They had an ex parte hearing according to their own emails, and they moved Dennis's supervised visits from the Division of Social Services, because they said he was recording all of their stuff, to the jailhouse.
So Dennis, you must be the expert at shoots and ladders here, because they don't know how to play the game, evidently, and now they're pissed off and don't want to play.
Right. That's the whole, what everything boils down to is that I've documented so much information on these corrupt judges, the corrupt circuit clerk's office, the Division of Social Services workers. I even have just some of the information or documentation that I have. One of them is a recording of the social service worker screaming at my children so much that I could hear it through 2 closed doors, and I was in the waiting room.
Yep.
And
yes, you heard that correctly, Jay.
So
you ready?
I'm just floored. If you work, I'll tell you all now. Look, if I see a social worker out there and you're working for social services and you're yelling at kids, you need to find a new job.
Yep.
The FBI became involved in the case in 2013. And the FBI did a forensic interview. They brought a special interview person to Springfield, Missouri, and interviewed the children.
So forensic psychologist.
Forensic interviewer for the FBI. I'm not sure who she was. But the FBI took that CD and this is then documented under the Freedom of Information request from the FBI, and also their own documentation, Division of Social Services. This forensic interview was sent to the Laclede County Sheriff's Department, and it disappeared. On this forensic interview, the FBI agent told me that the children had disclosed the most horrific crimes against them that had happened to them. They referred and sent the FBI, sent the Laclede County Sheriff's Department this DVD from the children. Now, this is the second interview of these children. Sent it to the detective there at the Laclede County Sheriff's Department. Now, look, I'm not against cops. I love, the police force. There are a few bad apples, like in every other title that they hold. I love the police department. So this was very disheartening for me, right?
Right.
And so when I got this information from the FBI, right, that they sent all of this information to them, I went in and recorded the interview with this detective. You know what this recording holds? This recording, I told him, I showed him the information. I showed him the information that I had. And he said, oh, well, let me go review that. Now, this dude was the one, he says on the recording, that he viewed the previous forensic interview of my granddaughter, saying that her new daddy did this nasty stuff to her. Okay, which he covered that up. But he then tries to, when I called him back for the follow-up, he tried to make an allegation against me that I was filing a false police report. And I told him, I said, you know what, Bill, that was his name. His name was Detective Morris. I said, you know what, Bill, that's why I recorded your ass. Because I knew this is exactly what you were going to do. You recorded me? I said, yeah. He told me it's not appropriate for the Sheriff's Department to investigate the Division of Family Services because they work with them. Now, I showed him the documentation that this social worker was not even employed, because I had her employment records from her boss, Division of Social Services. And I showed him the documentation in which she was the investigator on a case when she didn't even work there.
Right.
And he told me it wasn't appropriate for them to investigate because they worked with them. And this same detective was involved in making this FBI forensic interview that was conducted of the horrific crimes against my grandchildren, in which their psychologist had reported, and yet no of murder threats to the children if they told what was going on. Now, their emails show that the social service workers and the ex-wife, Amanda Rollins Colgan, attorney Ruth Schulte, discussed how they did not want the FBI involved in this case. Well, and they sent this information to the judge that Dennis had now involved the FBI and that they had to take the children into this supervised visits.
Actually,
that's why the children were taken into the supervised visits, because he was participating in a protected activity of the FBI's investigation. And I discussed this with the judge and send these emails to the judge in order to cover up these horrific crimes on my grandchildren.
So I have a question.
Go ahead.
I have one question. So Dennis did everything he could to protect his children, got the FBI involved to protect his children from crimes that are horrific crimes being done to his children. And they still let the mother take them and hide all the evidence? This is what social services is what our tax dollars are going to? Is that what you're telling me?
Yes.
Oh, Jesus. So
yeah, and they actually took the kids from me and
For the
put
state.
me in supervised visits because I was exposing what they were doing. Also, what they what the kids. I was trying to get the kids help, and that was the reason why they took them away from me.
What the
Was
judge
to
did in
shut
the
me up.
order, Dennis? What did the judge write in the order when he stripped you basically of your rights? What did that judge write? This judge that was involved in the ex parte hearings, proven by their own records, what did he write on your court order about what you
Oh,
had been doing?
you're talking about James? Okay.
Yes.
James wrote in the court order of 2015, September 21st, 2015, he wrote in the order that because I filed a federal lawsuit against the judges and lawyers, he found in favor of the mother on that, which none of these cases were in front of him. They were nothing that he could ever rule on. But this is the criteria he used to take my children from me permanently, or from his thoughts permanently. The other thing was because I filed a lawsuit against the school, he found in favor of the mother.
And he actually wrote that. So you don't have a First Amendment right to redress your government in the state of Missouri. This judge literally wrote this in the court order, the brass balls of that guy. Let me tell you what, when I sat in that courtroom and I looked in that guy's eyes, I knew what was going down. I knew that man had no soul. I knew what he was doing. And you want to know why? Dennis, tell him what your guardian ad litem asked you about, are you clairvoyant?
He asked me if I was clairvoyant because I seemed to know all the stuff that they were going to do before they did it. And I was like, no, I just know the game plan that you all run. It's the same one. Everybody runs the same game plan.
Yeah, it gets to be that way after a while, and what I'm thinking though is if the judge is making these rulings, number one, they're acting out of jurisdiction. You got to have jurisdiction. That has to be one of the pillars per Stump versus Sparkman. So when you act out of jurisdiction, now the judge can be sued in their personal capacity because they never had the authority to make that ruling. Never had.
Right.
Exactly.
So,
Now, Jay, remember when I was telling you about this case the other day when you were talking about, what was his name? Mike MC?
yeah. Mm-hmm.
Remember I told you they're very similar?
Yes, they are very
Now, I
similar.
told you this case is a doozy, did I not?
Yes, absolutely you did.
And the one thing that most people have in most states, the reason why they say, oh, my state's worse, is because they're exposed.
Mm-hmm.
They're exposing those things. So they makes them look bad. It makes those states look like there is something really going on. The one thing that nobody understands is Missouri is the richest state in the United States. Why? The only thing they got here is lawyers and social workers. That's all they do is steal kids.
Mm-hmm.
That is exactly how they make their money. They get government funding. They don't put it towards where it's supposed to go, and they stockpile it.
Yeah.
Because there's no separation of powers, Rosemary. None. According to that state statute, which is being challenged in Dennis's case in front of the Missouri Supreme Court, he actually challenged that with other things. His ex-wife made a response that she didn't understand what's being challenged in the Missouri Supreme Court. Now, the Missouri Supreme Court are the judge's boss, right?
Mm-hmm.
And if with the documentation and the evidence that was submitted, which is all public record in the Missouri Supreme Court, which is sitting there right now, I believe it's like the 20-something, the next Supreme Court ruling is going to come down. That's all being challenged. But in the Missouri Supreme Court, and I'm praying that they in fact do their job, they govern the judges down in the lower courts, they rule that there is a separation of powers,
Mhm.
because according to the Constitution and our Missouri Constitution, the governor, which, God bless his soul, he just came on board, our brand new governor, because our other governor, got disgraced and stepped down. God bless his soul. He's in charge, to ensure that the laws are, abided by
Adhere.
in the state of Missouri. And let me tell you what, in my heart, I truly believe that if this has to go to the United States Supreme Court, which it will, and which the federal district court judge said that the only other court that has jurisdiction over a case like this is the United States Supreme Court. So if in fact the Missouri Supreme Court does not, in which I think they will, but you never know, rein in these court judges, these district lower court judges that are case fixing, participating in the case fixing. Now this was clear case fixing. I mean, there's no way around that. I mean, working with ex parte, never, CC and Dennis and any of this. And even when he had the lawyer, they didn't even CC him in half that, because they thought he was basically a drunk, referred them clients. So, and keep in mind, that's part of the court record. Those text messages from that attorney are part of the court record,
Right.
So it's not any made up stuff.
Right.
But, if the Missouri Supreme Court does not come down with a no jurisdiction, ruling, because of the canon violations, because of the, separation of powers, I really don't care what they come down with. But if they do not, I guarantee this will be in front and on the lap of President Trump, because he is ultimately responsible for enforcing this, the Constitution, right? To ensure that these kind of things don't happen. And I'm sure that, the state of Missouri is not going to want to be exposed to President Trump, which they will be, because President Trump has to be notified. He has to be notified whenever a case like this goes into the United States Supreme Court, because it is his ultimate duty to ensure there is a separation of powers, that these kind of things do not occur. And this is not according to me. This is according to the July 31st, 2015 Department of Justice investigation into the Missouri family court in St. Louis County. Which
was investigated by the Department of Justice, which came straight from Washington, D.C.
Everybody in the state of Missouri works on the same team in order to steal the children and violate due process.
Exactly.
Juvenile
the problem is nobody's exposing it.
Well, if I could say something real quick.
Hold on, Dennis wants to say something, Sher.
You know how she was, Mom was saying about the FBI and all of that, and how DFS covered it up and didn't want them involved and everything. Well, there's an email that goes, and this is the clear case fixing. There's an email that goes directly to the judge from the social services worker that goes at like 10 o'clock in the morning, I believe it was. No, I think it was like 8 o'clock in the morning. I'm not exactly sure on the time, but it was somewhere around in there in the morning. Then it goes to the judge, tells the judge that Dennis had the FBI out there. The FBI came out and investigated and found nothing wrong. Okay. Now, that's what her email says, basically just laying out exactly what was going to happen out of this one lady's visit out there. Her name was, what was her name? Anyway.
Now, did she lay this out beforehand? Is that right?
Yes.
So this is like I'm not holding up any fingers.
Right,
Really?
right. And so that morning, she sends this to the judge. We find out in the later documents that the worker that went out there did not go out there until 1 o'clock in the afternoon. And her report says exactly what the caseworker, Amy Killian, already said that morning.
Yeah. That is
Yeah.
nothing. That Dennis has taken his children to the FBI, local law enforcement, and the hospital, and he needs supervised visits.
Okay.
Well, and the hospital one, real quick, Rosemary, I'm sorry, I don't mean to cut you off, but the hospital was, I took Nicole to the hospital because there was a bruise on her arm from her mother's boyfriend. And there was actually an ex parte in place right then at that point, that he was not to be left alone with the children. He was supposed to be under the mother's supervision. Well, Nicole told us that he squeezed her arm, and because she wouldn't clean up her room or wouldn't listen or something like that. So he squeezed her arm that hard, and I even called the guardian ad litem at the time, and I told him to meet me at the hospital. I said, come to the hospital. This is what is going on. This is what that was done whenever the ex parte was in, that I never got the hearing on, was in place. I also had the, with the ex partes, I have the circuit clerk on audio recording stating that the way the child protection orders work in Camden County is they continue, and then poof, they're gone.
Right.
They go away.
Yeah.
Now, to interrupt you guys, we have roughly about 11 minutes and we have to do our close cap too. So we can give you a couple more minutes to close it up.
Right.
So we can do
And
our.
let's do this, Rosemary. What I would probably say is, if we've got an average person that's going through a case, what would you recommend in very short cliff note versions? What would you recommend that they do to help themselves in their case?
Do what Dennis is doing, fight like tooth and nails and never give up. I mean, that's the point blank. You can't give up. Don't use pointless things that are not going to help you, like contract law, UCC laws, unless they're specific, certain ones. You can't go around using commercial liens on judges because that'll get you thrown in jail. You stick to their guidelines and beat them at their own game. You got to know the steps. You got to know what gameplay they're playing.
The other big thing is record Division of Social Services, record everything and everybody. Because if you do, and document it, exactly, that is your biggest ally.
Timestamp it. Put their name down, what their conversation was. It's a log. If you log it, it's legit. You put the date, time, what they talked about, who you talked to, what they were there for. Take a video recording at the same time. Do recordings, audio, it doesn't matter. Keep it documented. Because if you don't, see, I have this little recording device. It's audio. Because if they see my phone, they won't talk to me. So Cher told me, go get this recorder. And I put it in my pocket or my purse. And I walk in there and they don't know I have it. And they're on record. You might not see them, but here's everything they say. And it's recorded.
Exactly. Cher, anything to add right before we go here?
I just pray and I hope that, and here's the kicker, I don't know if one of the justices are going to be able to rule on the case, because she was actually an appellate court judge that ruled on Dennis's case that gave us the win. So, and then she's been elevated to the Missouri Supreme Court. So I don't know if she's going to recuse herself, not recuse herself, but here's what I say. Missouri Supreme Court justices, please rein in and stop this violation of due process. Stop the case fixing. Make an example out of Camden County Circuit Court and their judges that are now sitting on the bench and are being brought in as a retired judge, as Judge James was. Please make an example of these individuals and these attorneys that were involved in this. And I just hope and pray that they do the right thing,
Right.
you know, and we're looking at, you know, maybe a couple of days for that ruling to come down and stop the case fixing, you know, separate the powers. Judges, please take back the power in which was constitutionally, you know, stop letting social services run the judiciary.
Right.
Take
I
it
absolutely
upon
agree.
yourself and rein in these rogue offices of the executive branch, hold them accountable,
Right.
and do the right thing, you know, for the people. The people are counting on you,
Right.
Missouri Supreme Court justices. If they do not, this case, I am almost 120% positive, will go to the United States Supreme Court. It will go to President Trump because it's his ultimate responsibility to rein in these rogue judges
Right.
that are not following the Constitution, that there is no separation of powers. So I just pray that, you know, the Supreme Court justices will do the right thing. They will slap the unclean hands of the ex-wife in the case fixing. She
Right.
was
I agree.
aware. She knew it.
Yeah, I agree.
And
Yeah, I'm
protecting
gonna have to cut you off here because we're running out of time here. But thank you guys so much for coming on. We greatly appreciate you, Sher, Dennis. We'll
Thank
definitely
you, guys.
come on again in the future. Thank you again so much for coming on. We appreciate you.
Yes,
Thank
thank you
you.
for telling your story.
Thank you, Rosemary.
You're welcome.
All righty here. So I'm gonna go ahead and hit remove here on both of these here. All right. All right. So another amazing week of a story, just a doozy.
Now, I just told you, when I told you about this case, did I not tell you what you were going to hear?
Yeah, you absolutely did, 100%, and you were actually really accurate in what you were saying. Here's some of the things that
when it comes right down to it, we have 6 minutes.
Yeah, I'll give you some of the pointers that I think may help you or work for your case really, really quickly, and then I'll let Rosemary do the same here. UCCJEA that we talked about, Uniform Child Custody Jurisdiction and Enforcement Act. That's a good one. Look it up. Write it down. UCCJEA. FERPA. We've always talked about FERPA, Family Education Rights Privacy Act.
Yep.
If you've got something that's going on in your case that has to do with medical, check out HIPAA laws. Make sure that you've got your HIPAA laws taken care of. That's the Health Information Privacy Protection Act. Big time right here, number 4, what was just passed October the 1st, which is the Buchanan's Family First Prevention Act, and it's HR 253. Those are really good things that can help you in your case, especially the Buchanan Act, that last one, the Family First Prevention Act. It means that if your children are taking from you and they're taken from your ex as well, before they put them into foster care, they try and find another or your family member.
Kinship placement.
Right, exactly. So Rosemary, go ahead and give yours to the things that you might think of.
They need support. You make sure you have emotional support people. There's advocates that do support like me. Make sure you learn how to have coping skills because you got to keep your persona. You can't let yourself get all messed up in the courtroom. You got to make sure you're able to advocate for yourself and not start bawling your eyes out. Because you do that, you start showing emotion, you lose. That's how it works. You got to know the laws, the statutes of your state, or penal codes, or admiral law, or whatever it is that they use in their courtroom. You have to know those things. How to fight back. Know their procedure handbooks. Those are important too. Use those against them. If they're not following by procedures, you can use that and utilize that against them. Due process. Make sure that you get your due process, know your rights and jurisdiction. When they first take the kids, challenge the jurisdiction. because they don't have actual. And the biggest thing they always say is reasonable efforts for removal. What reasonable efforts? Did they give you a case plan beforehand? Did they do an assessment? Did they offer you any services before they did removal? If they did not do any of that, you go and you object to their saying reasonable efforts. They don't have reasonable efforts. They better prove it. What services did you provide you? What services were to prevent that removal? Because if the child is not in immediate danger or immediate harm or life-threatening, they can't legally take that child. So if they did not do reasonable efforts first and foremost, meaning services, offer you services, they can't legally take the children. And if they do, you challenge it. That's what you do. That's how you challenge jurisdiction in the family courts. So it's very, very important that you challenge before you get adjudication. You challenge from the very beginning. You challenge it. And if they don't have it, then they have to give you back your kids. That's all there is to it. They'll start all over again. They'll come back for them, but at least then you'll be 2 steps ahead of them. Make sure you know their procedure codes. But I do want to make the point, Missouri is not exposed. Missouri isn't even begin to be exposed. There are hundreds and hundreds of cases here that are some very similar to mine and Dennis's case, and they're not being exposed.
Right.
So everybody says they're credibility and advocates. Where are they? Because they're not here to help us.
That's right.
I have in 20 years, I've never had anybody to help me. And then Cher comes along and I help her. She helps me. Advocates need advocates. And if there ain't nobody stepping up, how can you call yourself an advocate? Because these cases here, nobody's helping with. And we need help.
That's exactly right. And Missouri has an entire Merrimack cavern full of cases, if that tells you anything. So I want to say to everybody while we're going, thank you all to the TNT team. I'm going to be calling on you even more. Again, I keep saying this, but I'm going to be calling on you even more here pretty soon because I know something you guys don't know. Little secret call last night that might get out there later. Something big is in the works, and when I say big, I mean huge. And we'll talk about that another time. But thank you again so much, Rosemary. You're excellent as always. And as we say every week, keep living, keep fighting, and keep talking normal. Love you guys.
Bless you all.
Down, nailed to the wire, known by the sin of our fathers. Let it all come out and burn like a fire. We'll shout a little bit louder, 'cause the night still has 1,000 eyes. And when the truth is brought to light, you and I will be free. Yeah, we'll be through every door, and the stakes get higher. Hard evidence is power. Turn loose a war, trade proof for the liar. We'll shout a little bit louder, 'cause secrets tell a million lies, but the truth is always brought to light. So you and I will be free. Yeah, we'll be free. to build the walls they hide behind, but the truth is always brought to light, brought to light. Secrets tell a million lies, but the night still has 1,000